called peer review, but consulting with other experts, relevant experts, to form the opinion, I think was part of his process in coming to an opinion. I think it's a fairly common process. I don't know of any expert who does not consult other experts in forming their opinion, but it has to remain his opinion, and it cannot be indirectly presenting the opinions of others. So let's treat this as a fairly straightforward application of the rule. Dr. Fowler can testify. He can testify as to what his expertise is, his training and experience, what he typically does in a case like this, what he did in this case, and what opinions in the area of his expertise does he have. He cannot refer to the opinions of other people, but he can refer to the fact that he did consult with other experts in the field. That's pretty much it. So it is, and I'm sure the state will probably be watching carefully during his testimony and objecting if they feel that an opinion that is being elicited is outside his very areas of expertise, and it would be for lacking foundation for such an opinion. And so if there is an objection for foundation, I would take that as this is an opinion outside his area of expertise, and I think the best way to do that is on a question-by-question basis at trial. So that's how we're going to proceed here. No expert or no deposition type hearing with Dr. Fowler, unless you want to have that for all of your witnesses as well. But I think it's inappropriate in a criminal case to proceed as such. He has an opinion. He can express it if there's a foundation for it. Bottom line. No indirect submission of other experts by referring to, I talked to Dr. X and he agrees with my results. That would be out of bounds. Absolutely. Okay? Does that kind of, does everybody understand where I've just drawn the line? From the state, Mr. Iyer, is that pretty clear what we're going to do?
Yeah, I understand that. Thank you.
All right, Mr. Nelson?
Agreed.
All right. Because you're not submitting the report, obviously, as an exhibit.
Right.
All right. Just want to make that clear. Okay. Does that take care of states 2? Mr. Iyer, does that take care of your motion? Any other motions? Let's see. We have 6, but you wanted to reserve that, I believe, because that's regarding use of force. Let's talk about 29 and 32 then, Mr. Nelson.
Thank you, Your Honor. Your Honor, 29, Defense Exhibit 29 is similar, I suppose, in its contrariness to the state's number 2. I think there is a distinction, however, between what a doctor relies on in terms of expertise, other information from other doctors. What we're specifically referring to is there are several references, and I apologize I don't have all of the reports here with me, but there are references within various reports about a doctor's personal clinical experience, somewhat anecdotal. Again, generally speaking, I don't dispute that can form the basis of their expertise or their opinions. However, in terms of the specific anecdotal details, I once had a client that had X number of nanograms of fentanyl, and this client was driving. There's no way to subject that to any sort of review. I can't cross-examine that particular witness on the specific details. Now, if they say, I'm familiar with a study, the study says this is the range of fentanyl from high to low, that's what I'm forming my opinion on, that's perfectly within reason. But specifically, I once had a patient who X, there's no basis under which I can cross-examine that or disprove that. It's sort of like saying, I once treated Santa Claus, right? I mean, and that's where I think the distinction is in defense number 29.
Let me ask Mr. Iyer, and you can remain there. What opinions exactly is the state seeking to elicit from its Dr. Vincent. Is that correct?
29 is different than 32, Your Honor. 32
Okay.
is Dr. Vincent.
Okay.
And, Your Honor, I believe Mr. Blackwell from the state will be addressing this.
As far as Dr. Vincent? So what are we talking about? You're just talking about generally people can't talk about anecdotal evidence.
Correct.
All the experts.
Correct.
All right. Schreier, what's your response to that?
I believe Mr. Blackwell from the state will be.
All right. Mr. Blackwell, if you would. And you can talk about 29 or 32 in any order you wish.
Thank you, Your Honor. I think the confusion here is what is meant by this nebulous term anecdotal. It's one thing if we have a case involving some novel scientific theory, as in all we have is a claim that this particular set of facts preceded this particular set of facts, and the only thing connecting them together is something that is called anecdotal experience of a physician. That's not what we're talking about here in this case. There is no novel scientific theory at all involved here. If we're talking about asphyxia or the various causal factors that go into cardiopulmonary arrest, they have virtually all been known about for a century. So this is not novel. We're talking here about clinical experience, which isn't just anecdotal. Clinical experience is a conglomeration of what's learned in med school, what is textbook medicine, what is learned in continuing education, and what's actually derived from on-the-job experience, all coming together to form what's known as clinical experience. And there is absolutely nothing in Rule 702, nor has counsel cited a single case where any court has ever said that a clinician cannot rely and talk about clinical experience.
Well, let me interrupt just for a second. We may be on the same page. I think even the defense says that, for example, a cardiologist could come in and say, I've been in the field for X number of years. I have a clinical practice where I treat patients who have cardiology issues, and I've probably treated thousands of patients, and that includes the range of symptoms from X, Y, and Z. I think what I hear the defense saying is the anecdotal evidence of then going to the basis, the foundation of their opinion they're going to give. Generally, these are the types of patients I've treated, thousands, hundreds, and not go, I had a patient once. I think that's the defense concern, and I share that concern that they talk about something that unless you're going to disclose that patient's medical records so that the defense gets cross-examined, it seems to be inappropriate. But a discussion of the length of their practice, the extent of their practice, the number of patients, the general range of symptoms and types of conditions that they treated seems to me perfectly valid to show the foundation for their opinion about, for example, a cardiologist giving their opinion about the effect on the heart, Mr. Floyd, based on everything. That seems perfectly logical. And I'm not even sure we're disagreeing on this. Are we, Mr. Nelson? Are we disagreeing on that? As far as what I've said is admissible.
You've articulated it better than I have, Your Honor.
So I guess we're down to the narrow issue of talking about individual anecdotal patients.
Well, yes and no, in the sense that I'm still not clear myself, Your Honor, because if, for example, a pulmonologist is talking about the science and the medicine of how it is a person dies of asphyxia, what are the stages? And they identify 3 or 4. That first you see this, then second this, and then third, and then finally the end stage.
Right.
And then the pulmonologist says, clinically, I have experienced and seen this in many patients. Each of the 4 steps or stages.
That makes sense.
It doesn't mean I'm talking about it in the context of Mr. Abernathy, but it does say that I've got clinical experience where I've actually experienced this in the field, and that's a part of my knowledge base that I can share with the jury.
And that seems appropriate.
And so that's, Your Honor, where we're at then. And in that instance, we're on the same page. We don't intend to bring this up as an individual case study, as in talking about an individual patient. But the clinical examples will simply be that. They will be clinical examples of known medical causation mechanisms. And here's how we see it in the actual field, going from the textbook and the science and the abstract to reality. And the clinician should be able to talk about that clinical experience.
And I agree. I think the only exception is, I had a patient once. I think that's problematic because it does not show the general experience that they've had. It could have been a rare, idiosyncratic response to some type of situation. That's the problem with anecdotal evidence. You don't know if it's just, something that was rare and this person had a reaction that, and so that's the problem I think with those single I had a patient ones. But I think everything else you're talking about, I've had patients with this thing talking about the commonalities and what they see, and that forms the basis of their opinion. I think that's absolutely proper. So I think that basically, and what I'm going to rule is, you can't get into recounting individual patient anecdotes because you don't know if it was a rare or odd response to a certain medical condition. But generally talking about their experience and treating patients with this, and this is what he's found, that makes sense. So no, I had a patient once evidence. Everything else I think is pretty much in bounds. So that's how I'm going to hold.
Thank you, Your Honor.
Okay.
Did
you want to go right to number 32?
Going into Dr. Vincent, I think Your Honor has fairly well addressed the issues with respect to Dr. Vincent in the discussion around Dr. Fowler. They both are forensic practitioners, and the forensic part means that their particular expertise resides at the interface between science, medicine, and the law. And the sort of workhorse of the forensics is all the investigation and work they do around the specific science, meaning the investigation that takes place. You heard with respect to Dr. Fowler, for example, that he would have looked at police reports, medical records, medical literature, and even down to getting statements from patients, potentially others, when he was citing the commentary to the rule. This is the stuff, the wheelhouse of forensic fill-in-the-blank, forensic pathology, forensic psychiatry.
Well, tell me first, though, why forensic psychiatry in regards to opinions about Mr. Floyd are relevant to this case.
This case very much involves the central issue of behavioral sciences, Your Honor. And here's how it comes up. As Your Honor is well aware, Mr. Floyd said that he was claustrophobic when they were trying to get him into the squad car. He said that he had anxiety. He said that he was scared as F, the court knows what.
Yep.
In that respect, that he had panic and anxiety. Now, in the face of this severe anxiety, the defense has taken the position in its papers already that Mr. Floyd was in fact resisting arrest as opposed to simply being frozen in fear, which is a psychological state or condition. They have taken the position that he was intoxicated, as shown in this conduct, as opposed to the conduct being reflective of his severe anxiety. They have taken the position that the physical symptoms that he showed, including the white substance around his mouth, was indicative of drug use, as opposed to a side effect of severe anxiety. Was Mr. Floyd hallucinating in this sort of altered state of being, or is it that he was simply having a reaction again to the severe stress and anxiety, again psychological states or conditions? And then there's excited delirium. So it is, in fact, an issue that's put into contention in this case by positions taken by the defense. And the defense is no more in the mind of George Floyd than anyone else in the case. And so what a forensic psychiatrist is allowed to do is to talk generally about how human beings would ordinarily respond to these kind of traumatic stimuli. Not how George Floyd does specifically, but how humans do generally. So it's not, as Mr. Nelson suggested, a psychological evaluation of George Floyd. And if Your Honor will look at even the comments in Rule 702, I think the 1977 comments, about the expert opinion, that the rule that is 702 contemplates expert testimony in the form of lecture or explanation
The expert may educate the jury so the jurors can draw their own inferential conclusions from the evidence presented.
Well, and that's true, and I agree with what you're saying, but my concern being that this is expert testimony about intent or knowledge or what was going through Mr. Floyd's mind at the time. And I think if we look at State versus Provost, for example, which was a mental illness case, but it was clear in that case that in the guilt phase it was a two-phase mental illness case. Then in the first phase, expert testimony about the thought process, in this case of the defendant, was excluded as improper. It's an improper topic for expert testimony. It seems to me that the relevant and appropriate testimony in this case from Dr. Vincent would be limited to watch the video. These are consistent with anxiety. This is consistent with a post-traumatic stress disorder response. This is consistent with claustrophobia. I don't think the doctor can even go to the extent, given Provost and the other cases about expert testimony talking about other people's, actually saying he was anxious. He was, in fact, feeling claustrophobic. But watching somebody who is not even a patient of hers and say it's consistent with an anxiety response, and to say why what she has seen is consistent with that. I also think, because her opinions are broad-ranging, I think the state would admit that. We go towards a lot of the background of Mr. Floyd, which may be appropriate in her field, but it's not appropriate to bring all that in, character type evidence. But I can understand why she did that, went in and talked about it. But I think it seems to me that the psychiatric evidence, so she's a medical doctor in addition, correct? This is not a psychologist, it's a psychiatrist.
That's right, Your Honor.
So the medical manifestations, the symptoms that Mr. Floyd was showing at the time, seems to be inappropriate for a psychiatrist to say the physical manifestations we see here are consistent with. And I think to go beyond that, even to say, and it's my opinion that he was suffering from anxiety, I think would push the bounds of what is allowed as psychiatric or state of mind type evidence. Experts cannot opine on state of mind, but they can say the behavior is consistent.
That's precisely what we plan to do, Your Honor.
Okay.
Per State versus McLennan, which says the same thing,
Right.
that we can discuss consistent with, but not take the next step.
Exactly.
To say that it is reflected in this case. That's for the jury to decide.
Yeah, and there's a great deal of, discussion and certainly an honest part of her opinion, talking about the legacy of the historical trauma from slavery and Jim Crow and all that. None of that seems appropriate for the limited medical testimony that she'd be providing. So it seems that she can talk again about what did you do in this case, but some of the opinions seem to be beyond an appropriate focus in this case, because I think we always get in a dangerous situation when people are opining about what somebody else was thinking, even a psychiatrist. So
Right.
okay, so I would allow her testimony as far as that, but I'll give Mr. Nelson a chance to respond before I do that. Anything else though, Mr. Blackwell?
No, Your Honor, that covers
Okay,
it.
thank you.
Thank you.
Mr. Nelson.
Thanks. I do agree with the court's interpretation of the wide-ranging opinions of Dr. Vincent, and I'm not questioning Dr. Vincent's expertise. I think and I do believe that there are some potentially serious foundational issues with some of her report, in terms of relying on media presentations as opposed to actual records of Mr. Floyd. I think that we have to be very careful in this regard, because this is where I think the state is in the most perilous danger of opening the door to Mr. Floyd's history. I think ultimately the question, and I would submit to the court, is limiting Dr. Vincent's testimony to these are consistent with PTSD, right? So the question, these behaviors are consistent with PTSD. Taking that statement, does that open the door to, or does it leave a jury with an inference that Mr. Floyd in fact suffers from PTSD? And how can someone actually make that diagnosis based on a Washington Post article or a Star Tribune article, right? And so I understand the limitations of the court's ruling, and I understand the state's intent, but I do think that they get very close to opening the door to the 404B, all of the 404B evidence.
I will allow the state to have Dr. Vinson talk about that, about this. It's consistent with anxiety. It's consistent with. Certainly, the defense has the right to cross-examine the basis and say, are there any medical records that show he had PTSD? Because unless there's a diagnosis somewhere, we are getting into close to other evidence which may not be admissible as the basis of the opinion. It's fairly speculative to begin with, even for an expert, to start talking about, I can tell just from that video that person was suffering from PTSD. At best, I suppose, and I'll have to think about this part of it, I think what we get into is, was he suffering from PTSD? Do we have that in a medical record? That would certainly make it easy if there was something in a medical record that he has a history of PTSD. Medical records is, the business record it is, could be used for that. But when we start getting into his life and dumping all that into this trial, simply to form an opinion that his actions were consistent with PTSD seems to reach too far. I think if she talks about, I've reviewed circumstances of his life generally and not talk about many things that she did in her report, I think that gets problematic. So I think we all need to think about this, and I'll try and think of it myself on what the limitations would be. It certainly seems at this point that she could, just on the basis of the videotape and her knowledge as a psychiatrist, talk about his actions are consistent with a panic attack. His actions are consistent with anxiety. His actions are consistent with somebody who suffers from claustrophobia, because that he says I'm claustrophobic. He's scared. So I think the one that may be a problematic is the PTSD.
Well, I mean, and Your Honor, even if you look at these actions are consistent with panic, or these actions are consistent with claustrophobia, it certainly opens the door to the 2019 arrest when his actions were inconsistent.
We'll get to that. We'll get to that, because I appreciate. Are we going to argue that tomorrow?
We can argue that tomorrow. We wouldn't need much time.
I think we would. I think we need to do that tomorrow, because that's going to be also a fairly extensive set of circumstances. So, Mr. Blackwell, did you want to respond to anything at this point?
The umbrage I'm taking with this exchange, Your Honor, having to do with being able to interpret George Floyd's state of mind, is that it's exactly what the defense does when they say that George Floyd, for example, is resisting arrest, which implies that he's intentionally doing so, state of mind.
But they're not going to have an expert testify that he was resisting arrest.
No, they'll have a lawyer who says it, and Your Honor, which is probably worse. And so that we have to address that, and that is absolutely state of mind. And what I would say about this, again, I'm just quoting from, briefly, the State versus McLennan case, 702 Northwest 2nd, 219, talking about, again, behavioral science testimony. The experts in each case are merely outlining probable responses to a traumatic event. It is clearly within the realm of all human experience to expect that a person would react to a traumatic event, and that such reactions would not be consistent or predictable in all persons. Thus, referring to the Michigan court, they held that the Frye test is inapplicable to such evidence.
Well, I don't think this is a Frye issue.
Yes,
I
Your
agree
Honor.
with you on that.
But it says, so long, though, as the purpose of the evidence is merely to offer an explanation for certain behavior. And that's all we're doing, is offer an explanation for certain behavior. I don't doubt for 1 second that counsel is anxious to get into 404B. I think when we say good morning, he'd like to get into 404B, but we'll talk about that tomorrow, Your Honor.
Right. I guess what I'm saying is your expert can testify about what you saw was consistent with anxiety, consistent with a panic attack, consistent with somebody suffering from claustrophobia. I think the problem is if she actually starts talking about PTSD, I think that opens the door to a lot of things. So I'll think about that a little more as far when we get there. But I think if it's limited to consistent with those things, we avoid the dangers of having experts talk about state of mind. Yeah, Mr. Nelson's going to say that Mr. Floyd was resisting arrest. He's entitled to argue based on the evidence. As the state is going to argue in response, no, he was claustrophobic. This is not an act, is what they're going to say.
Correct.
And so I think that's the difference.
Yeah.
And so and certainly the state, I'm sure, will be arguing that in closing. So it's your interpretation doesn't tell me what I'm going to allow the expert to do is where I'm at. Either side I wouldn't expect. Just because it's your argument doesn't mean I'm going to let an expert testify to it.
Right.
So,
all right.
okay, I think we pretty much have the limitations there.
I would like to make a record, Your Honor.
Sure.
relevant to-
Why don't you do that?
Your Honor, and I know that we're short on time today, but I am gravely concerned, and I know we've been dealing with these motions this morning, but I am gravely concerned with the news that broke on Friday relevant to the civil settlement in this case. This is, by my count, notwithstanding all of the high-ranking state officials that made comments at the onset of this entire situation. But by my count, this is the third highly prejudicial and incredibly prejudicial press leak or press release that has very suspicious timing, to say the least, and has an incredible propensity to taint a jury pool. Because what we've been hearing from the jurors who've come in so far is they may run into a headline record $27 million civil settlement. If they're and the court has granted permission for these people to be scrolling through Facebook, it's going to be unavoidable. And I think that there are certain things that the court should strongly consider. I think there are things that if the court denies those requests, there are things that the court should potentially be obligated to do to protect the jury from future questionable press releases. One thing I think the court should strongly consider is a request for a continuance, Your Honor, and a renewal of our change of venue motion. The fact that this came in the exact middle of jury selection, it's perplexing to me, Your Honor, that whose idea it was to release this information when it was released. When we have jurors in the courtroom, we have jurors seated in this case, and we have 7 more jurors to potentially find. If the court is not inclined to continue or change venue, and we can address these again further, I think there are things that the court must do, which include calling back the 7 jurors that are currently seated on this case and inquiring. I think there needs to be specific inquiry as to this settlement. It's amazing to me is, you know, they had a press conference on Friday where the mayor of Minneapolis is on stage with city council, and they're using very, what I would say, very well-designed terminology. The unanimous decision of the city council, for example. It just goes straight to the heart of the dangers of pretrial publicity in this case. I think the court should also strongly consider providing the defense with extra strikes. It's another potential remedy. And I think the court should strongly consider the immediate sequestration of jurors throughout the pendency of this case. And we can address these things, but
I'll let the state respond, because you have several motions in here, basically. Continuance of the trial, calling back the 7 and voir direing them regarding any exposure to this information, and for extra strikes. And the jury is not quite ready. They're not going to be ready till at least 9:10. So I'll ask for the state to respond to those
And
briefly.
Judge, I would also just
And then I'll
simply,
take all that under advisement.
I would also just simply add that I think that in view of some of the press that came out over this weekend in terms of where this information came from, I know that in the companion cases there was a pending motion of, and a pending motion of one of the other defendants for a hearing, and I think that this would be a proper subject of that hearing as well.
Mr. Slisher?
Thank you very much, Your Honor. If it pleases the court, with respect to the actual news of the $27 million settlement, all I can say to the court is there are some things that the state of Minnesota and this prosecution team can control, and there's some things that the state cannot and does not control. We can control the witnesses we call, we can control the evidence that we bring in, we can control the motions, but we cannot and do not control the civil aspect of the case. We cannot and do not control the Minneapolis City Council, and we certainly cannot and do not control the news cycle. The media reports on what they report on things that they find of a public interest, and apparently they've done so here. I would also urge the court, just like everything else, take a step back, look at the actual effect. And through the process of jury selection, what we've seen here, Your Honor, is that while individual jurors have been exposed to media in the case, and they certainly have, the jurors that we've seated have expressed that they can set anything that they've learned outside of the courtroom aside and judge the case based on the evidence. And there's no reason to believe that our future prospective jurors, who we're going to be questioning later today, won't be in the exact same position. There have been some stories that have come out that haven't even been mentioned in our voir dire thus far. And so whether or not a juror learns of a civil settlement in this particular matter, it really is a subject for individual questioning and individual review. You know, in terms of the sort of inference that this was somehow coordinated by the state of Minnesota, it wasn't. I don't know even how it could be if we wanted it to be. And as far as the language that was used by those people who were speaking, I certainly didn't see what comments they were going to make before they made them. It seems to me if they reported a unanimous decision of the city council, it was because all of the city council members agreed with that decision. And so I think that we need to reflect on that a little bit and also just continue with the voir dire as it's been. As the court noted, we had a prior exchange in chambers. The court has...
You would agree it's unfortunate, wouldn't you?
That it's unfortunate?
That we have this reported all over the media when we're in the midst of jury selection as far as timing.
Yeah, it's certainly not my preference, Your Honor. I don't even know which way that cuts. If that cuts for us, if that cuts against us. You know, some jurors
The problem
might...
is it cuts.
What's that?
The problem is it cuts.
Yeah.
That's the concern, and I think the defense has a legitimate concern. I think the state even has a concern.
Absolutely. We are, it would be our strong preference that we'd be trying this case in a vacuum with no pretrial publicity. It certainly would. It would make things a lot less complicated. But that's just not where we are, right? I mean, this is the case that we have. The court has taken some pretty substantial measures in this regard to protect against any negative effect of pretrial publicity, including tripling the number of strikes for the defense and for the state that would normally be allowed in a case of this type. And we haven't even used them all yet. Neither of us have. And so I think that the continuance motion for that basis, obviously the state has moved for continuances before, but I would oppose a continuance on those grounds, Your Honor, because I don't think it's warranted. I would oppose any extra strikes at this point as being premature. I wouldn't be surprised if the jurors we questioned don't pay as much attention to us as we think they do and don't know about the settlement. Maybe they do, maybe they don't. But I think that that's something that we should take up with individual questioning. Let's wait till we have a problem before we start thinking about a solution.
Yeah, there's been, think what has to be characterized as prejudicial pretrial publicity, not just about this, but on other matters that we've tried to dance around, or I've tried to dance around with the jurors. And I'll do the same, and I might even be a little more specific and talk about, or have you read anything about any pending civil litigation? And so I don't think it's appropriate for extra strikes, because if they have read something that makes it that they cannot put that aside, I think it's more a matter of more likely a challenge for cause. So I'm actually going to deny the motion for extra strikes. I'm going to grant the motion that at some point, probably after we are finished selecting, that we call back the 7 to see if there's been any, if they've read anything and if it changes their minds about whether they can be fair and impartial. I think the defense is entitled to that, and I wish people would, city officials would stop talking about this case so much. But at the same time, I don't find any evil intent that they are trying to tamper with this criminal case. I think it's just the civil litigation was going on, and I'm guessing that both sides said, one side said, well, the result of the criminal case could go one of two ways. For one, it would probably raise the amount that has to be paid, and the other result, that it would lower the amount that would be paid. And so I think they all kind of, the timing is not related, I don't think, to this case. I think it's related to just their calculation about exposure, liability, and that. So I don't, it's unfortunate, and I wish they hadn't done it, but I don't sense any evil intent on the timing.
Your Honor, I would just note in the Nor case, within 24 hours of the verdict is when the civil settlement was announced, and unless those parties within 12 to 24 hours suddenly reached a complicated decision, we've got a mayor who's a lawyer by trade. He should know better, Your Honor. And obviously, Mr. Ellison's son is a city council member. And I'm not accusing Mr. Ellison of anything. I just want to make that very clear. But it is, it is profoundly disturbing to the defense, because ultimately the goal of this system is to provide a fair trial. And this is not fair.
Like I say, I think it is unfortunate. We're going to continue to proceed for now. I am taking your motion for a continuance of the trial date under advisement, however.
Your Honor, if I may just
Sure.
please respond to the inference, and I know counsel is stating that he's not accusing this, the Attorney General of anything, and for good reason, because there's nothing to accuse him of. His son's on the city council. They're not coordinating anything in this regard. The mayor is a lawyer. The mayor has a job to do. He certainly doesn't take direction from me. I don't think I've ever met him. These are just things that happen kind of independently of what we're doing here. I think if we let them focus on their job, I don't know what happened in the Nor case with the civil settlement, wasn't involved in it. But if we let them focus on their job, we'll focus on ours of giving the defendant a fair trial and proceeding with jury selection. This is probably going to proceed just fine. The change of venue, I would also just make a record there. It wouldn't be appropriate to change venue on this basis on something that's national news. It wasn't particularized to the city of Minneapolis. Thank you.
All right, let's stand in recess until 9:15. All of our jurors are here. They're finishing up the orientation video, and Mr. Schaefer will be bringing them in for the group instructions. While we have a moment, what motions are we going to address tomorrow?
I think there's just one left, Your Honor.
The May 6, 2019 404B evidence? State agree with that? I think so. Sounds like it.
I don't think so.
All right. And let's start at 8 o'clock for that one as well. And that should be the last time we have to start at 8 a.m. then. Which feels like 7 o'clock in the morning to us all right now, I know. So. We have them? Greg, what's going on?
Just bring them.
Go ahead and take any seat you'd like. Be seated. All right. All right, good morning, everyone. First of all, can you all hear me? Give me a thumbs up if you can hear me. All right, because we have hearing assistance devices if any of you have any concerns about being able to hear everything. Well, my name is Pete Cahill, and I am one of the judges of the district court. You have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure the judges or the jurors who are selected are impartial, you are also judges, you're just judges of the facts. But jurors who are selected are impartial. The law provides that the court and the attorneys for the parties may ask questions to all prospective jurors, which must be answered under oath. First, thank you for filling out and returning the questionnaire that was mailed to you. Your contribution to the important and serious matter at hand is best served by your continuing to provide full and complete answers to the questions that you'll be asked today. Those questions will follow up on issues from the questionnaire and possibly other topics. After the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others of you for what is called cause. In either case, it does not mean that you are not a fair person, and you should not take offense in being excused. I also ask that you not take any offense at any question you may be asked. We must pry to some extent in order to explore some opinions you might hold and hear about experiences that you've had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. Now, in the normal course of trial, charges are usually added or subtracted from these charges, but those are the charges today for you. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. And I'm going to have the participants in this case introduce themselves, starting with the state.
Good morning. My name is Steve Swisher. I represent the state of Minnesota.
Good morning. My name is Christina Marinakis, and I'm assisting with the prosecution.
Good morning. My name is Keith Ellison, and I represent the state of Minnesota.
Good morning. Aaron Eldridge for the state of Minnesota.
And Mr. Nelson, if you'd introduce your client and your team.
Good morning. My name is Eric Nelson. Behind me is my assistant, Amy Voss, and together we're representing the defendant, Derek Chauvin.
All right, by show of hands, does anybody recognize any of these people? Actually, I should say more than recognize. Are you acquainted with any of these people? Okay, and you are juror number? 5-1. 5-1? Yes. All right, and who do you recognize?
Mr. Ellison.
Okay, have you dealt with him personally?
He was my congressman, and I voted for him, and I voted for him for Attorney General, so I don't know how much that weighs. So I don't know how much that weighs that I
Okay.
voted for.
All right. I'm thinking more of anybody who has a professional relationship, personal relationship with him, aside from the fact that he is an elected official. Anybody. Okay. Good to bring up, though. It's always better to err on the side of more information than less. So, all right. Does anybody recognize anybody else from the Attorney General's office? Are you acquainted with anybody from the Attorney General's office, including other attorneys who might be in this case, including Mr. Jerry Blackwell, and other people who might work in that office? Does anybody have a close relationship with anybody there? All right. Anybody know Mr. Nelson or have any dealings with his law firm? Okay, no hands. Anybody recognize anybody in the courtroom for that matter? Okay, let me stop. Not recognize, but are acquainted with, have a relationship with the people in this courtroom. Okay, thank you. You have been given a copy of a list of potential witnesses, and I'd like to review that before your individual questioning. At that time, you'll be asked if you know anyone who is on that list. Now, one of the things the attorneys may not do during jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in all criminal cases so that you may keep them in mind as you answer the court's and the attorney's questions, because they will touch on those topics. So I will instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove innocence. The presumption of innocence remains with the defendant throughout the trial unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now, if you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. But in determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, relationship to the parties, their ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. There are things you should not do during jury selection. You are not investigators. You are not to go out to do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved, the lawyers or the witnesses. Do not be offended if the attorneys, parties, witnesses, or spectators do not speak to you. They know it will be improper to contact you during trial, and they will confine themselves to contact as the part of the normal selection process, otherwise confining themselves to a brief greeting. Now, during the selection process, your family and friends will be curious as to what you are doing. You may tell them that you are on a panel of potential jurors in a criminal case, and that is all you should tell them. The length of the trial, if necessary for your employers, you could probably mention the length. But other than that, you should not talk to people about this case or what you are doing. Now, since that is all you should tell family and friends, and possibly an employer, that is all you should tell the general public. So please, during the course of this trial and during these proceedings, refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access such social media tools, but please do not publish any information about this case or your thoughts about this case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about this case, and do not talk at all to anyone who is involved. Now, because of the nature of the charges, this case is receiving media coverage. Do not read about this case in the newspapers or online, and do not listen to news about it on radio or television. This trial, including jury selection, is being televised, but no video of you or any other juror will be taken at any time, now or during the trial if you are selected. Also, your name will not be used in the courtroom at any time. You will only be referred to by your random number to protect your privacy. The audio of anything you say will be broadcast, unless we need to discuss something deeply personal, extremely sensitive or embarrassing, or which would tend to specifically identify who you are. In those cases, I will order that the audio not be broadcast so that the only people who can hear what you're saying are within this courtroom. You will still have to answer questions, and a record will be made of it, but without the audio or video broadcast. Now, just checking who our first jurors. I believe juror number 51. You are going to be our first juror, so I'm going to have you remain. Everybody else, the deputy will escort you back into that other courtroom to wait your turn for individual questioning. Please keep in mind all the COVID restrictions we are doing. I will be wearing a mask during the individual questioning since I'll be closer to you, and also I have had my first shot, so hopefully that will give you some comfort there. So if you could follow the deputy. And juror 51, if you could come on up. And if you could stay along the back wall. Have a seat. Well, good morning.
Morning.
And you are juror number 51.
Correct.
All right. Before I turn it over to the attorneys, a couple matters. First of all, I'm going to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you'll truthfully answer all questions about your qualifications to serve as a juror?
I do.
Thank you. All right. First of all, you were given a questionnaire, and thank you for filling it out and getting it back to us. Obviously, you spent a considerable amount of time on it, and we appreciate that because it kind of gives us a leg up on where we're going. Everything true that you answered?
Yes, Your Honor.
Okay. And are there any changes or additions? Because here's what happens. We give you the questionnaire in December, and then it's a few months. You may realize you forgot to put something in, or maybe one of your opinions has changed. But in any case, is there anything you can think of right now that you'd want to change or amend, anything like that?
Your Honor, I could I ask a clarifying question?
Sure.
I inadvertently heard, when I left on Friday, I turned on my radio and I inadvertently heard about the settlement that Minneapolis had. So that has changed, obviously, since I did the questionnaire.
Right. One of the things I was going to say is that inadvertently, when we talk about what you know about the case, you may be exposed to a headline, despite your best efforts, because the questionnaire did say avoid media, but given the pervasive nature of the media for this case, what do you remember hearing?
I remember hearing that the pre-trial settlement was determined to be $27 million
Okay.
from the city to the family of Mr. Floyd.
Okay. What do you think that means for this case?
Well, from my own experience of understanding more on the civil side, and I work in human resources, so I work with unemployment insurance, appeals and hearings and judges and such. Generally, the preponderance of the evidence in civil cases leans towards guilt. My guess is that with that large of a settlement, that the city felt that they would not prevail in civil court and therefore didn't feel like they could make a case to overcome the preponderance of evidence. I know there's a difference between reasonable doubt and preponderance with civil and criminal, but I do think that I believe the other detail that I heard is that it was the largest settlement outside of Justine, I think her last name was Damon. So I'm sorry that I know that much, but
Like I say, I think I've never met a juror who did blatantly disregard my orders. It's just that, in fact, even before that was announced, I've said to many jurors, inadvertently you might run into a headline or somebody even discussing with you and say, hey, did you hear what's happening? And we've told you don't reveal that you're a juror, and so you can't exactly stop them. So I think you've kind of laid out your view of it. Would you agree that since you seem to have a fairly sophisticated knowledge and experience with civil litigation, that sometimes settlements are made because things are in doubt, or they don't know the result of what's going to happen in whatever case, civil or criminal? My concern is, I think everybody's concern actually, is that might move you along the scale towards one side or the other and affect whether you can be impartial in this criminal case. What do you think?
I would agree with what you're saying. I would like to think of myself as somebody who's coming in impartial. However, even for my questionnaire, I had to be honest about opinions that I hold and that they were already strong opinions. I think that when I heard that settlement also being somebody who lives in Minneapolis, and I mean, I drove by the 3rd precinct this morning. I live there. I drove by 38th in Chicago yesterday. I think that large of a settlement, again, being in human resources, we sometimes settle with employees, but it's pretty minimal.
Okay.
It's just to, for lack of a better phrase, to have something go away. But in this case, it felt like, I mean, when I heard that, I almost gasped the amount.
Okay.
And so I would like to think of myself as somebody who tries to be impartial, but I've just been exposed to so much information, and when that happened, it leaned me so
Right.
far to one side over the other that I couldn't say under oath that I'd be able to take that out of my mind.
Okay. And I've often said to jurors, you know, you're not a failure as a juror if you say this is not a case where I can be fair and impartial. It's as long as it's an honest answer. Do you think that would be your honest answer?
Sir, with there's 2 officers that I wouldn't recognize by name. In those cases, I think I could come in and say, I truly believe I could be truly neutral. With this particular officer in particular, I'm unfortunately, honestly, I don't think I could be, to be honest.
All right. I'm going to excuse you from this panel, so I appreciate your honesty and your candor on this. There was a lot of other information we might have gone over, but I think...
I am sorry, because I do.
Oh.
This is something I think is historical and important, but I also feel like everybody deserves a fair and impartial jury, and I have to be honest that maybe the other officers, like I said, I'd be more than willing.
Okay.
But I just think my mind is made up.
All right. Well, I thank you for your service.
You're
and
welcome.
The deputy will escort you out, take some paperwork from you, and you're off jury service, so you don't, unless you get a summons years from now, you're good to go.
Thank you, Your Honor.
All right. Thank you. Great. Yes, sir. If you come on up. Good morning.
Morning.
And you are juror 52.
52, correct.
All right. A couple things before I turn you over to the attorneys. First of all, I'm going to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I will.
All right, thank you. Also, I'm going to ask you to move close to the microphone so that we can pick up your voice. Also, I'm wearing my mask, given how we are fairly close, but there is plexiglass between us. There's plexiglass between you and the attorneys when they're asking questions. So if you feel that it would be more comfortable or that we could hear you better with the mask removed, feel free to remove the mask while you're being examined. Your choice. I'm not going to make you do it, but if you feel comfortable doing it, that'd be fine.
Got it.
Okay. First of all, you filled out the questionnaire, and thank you for doing that. A lot of good information here. Is everything that you answered on that questionnaire true and correct?
Yes.
All right. Any changes or additions to the questionnaires that you can think of right now?
No, sir.
Okay. And the attorneys will probably go into more individual questioning about this, because sometimes when you fill that out months ago, other things happen. You hear other things that might change opinions. Or you just, in reflection, think, oh, I probably should have put that in there. Or anything like that. Right now, it sounds like you don't have anything to volunteer, but is that correct?
Correct.
But the attorneys might prompt a memory. Feel free to add something that is different from your questionnaire. You're not going to get into trouble. What we're looking for are honest, open answers as we go forward. So, you weren't supposed to read any articles or watch any media about this case. But we recognize that since this was months ago that you filled out the questionnaire, since the time you filled out the questionnaire and now, have you inadvertently been exposed to information? For example, maybe you see a headline in passing, or you talk to somebody about, somebody says, hey, did you hear? And it's something about this case, and since we told you, don't tell anybody you're a juror in this case, you can't exactly stop people. Anything like that happen to you that you became inadvertently aware of some information about the case since the questionnaire and today?
Yes, definitely. I've seen headlines just speaking on the case coming up, just saying the dates, what to look out for, just different headlines like that through media outlets, so yahoo.com
Okay.
in particular.
Anything other than like kind of the basic logistics of the trial?
No.
Okay. Did you hear anything about any other, about any of the parties, the attorneys, pretrial matters, related civil litigation, anything like that?
No, sir.
All right. And the reason we ask is because you may have heard things about the case, and that was our first question on the questionnaire. The whole point there is, it's all right to have read about it. It was hard to avoid. It's all right to even form opinions based on what you've heard and seen. But as a juror, you have to put all that aside. Decide this case just on the evidence you hear in the courtroom. Essentially be a blank slate. And apply the law as I give it to you. Do you think you could do that?
For sure.
Okay, thank you. All right, we gave you a long witness list. Did you recognize any of the witnesses on it?
No, sir.
All right. And we estimate that the trial is going to be about 4 weeks once we start. And we're anticipating starting on March 29th at 9 a.m. Does that trial length, can you make that work?
Yes.
All right. Any concerns about being on this jury as far as timing?
No.
Okay. All right. In that case then, I'm going to turn you over to Mr. Nelson, who's going to ask some questions first. Regarding juror number 52, you may inquire, Mr. Nelson.
Good morning, sir.
Good morning.
Thank you for being here this morning. Were you here on Friday too?
I was, yes.
Well, thank you for your patience. Sometimes these things take a little bit longer than we anticipate. So what I would like to do this morning, sir, is kind of ask you a series of kind of broad and general questions to get to know you a little bit better. And then I'm going to follow up with some specifics on your questionnaire.
Okay.
Understanding it's been a while since you filled this out and you may not remember exactly what you wrote.
Okay.
All right. So let's assume you and I were to have met in some other circumstance, a social event, a party, whatever. What are a couple of things about you that I would walk away knowing?
That I'm a pretty friendly, positive person. Generally have a positive attitude, look at a positive outlook on things.
Okay. Any hobbies, special interests, things of that nature?
I'm majorly into sports, big basketball fan. Sports, and then writing and music. So,
okay, great. Now, in your personal, well, let me ask you this: you got at some point you learned that you were a prospective juror in this particular case, right?
Correct.
And you had obviously heard about this case prior to receiving that notice. When you got the notice that you were a potential juror in this case, what was your initial reaction?
I think I was more like, it's kind of odd because I never expected to be on jury duty anytime soon during that period. So it was just kind of a surprise, shocked.
Okay.
Yeah.
Did you, knowing that it was about this case, did you have any concerns for your personal safety, the safety of your family, anything of that nature?
No, not at all.
Okay, great. And how about with respect to COVID-19? Do you have any concerns? You've obviously we've taken a lot of precautions here.
Well, not at all.
Okay. In your personal or professional life, can you think of a situation where you were called upon to resolve a conflict between two people?
Absolutely. So in my personal life, I coach youth sports, and a lot of times parents have conflicts with maybe how much their kid is playing. So a lot of times I might have to step in and mediate, maybe amongst two parents that have a conflict within that, and it's just a matter of just communicating and just giving everybody a platform to talk and listen, giving the next person a chance to listen to actually what's going on.
Okay. I think that's a great example. In terms of, so you would say that hearing both sides of the story is a pretty important component?
Everybody has to have a chance to kind of communicate what's going on or what their thoughts are.
Sure. Now, in terms of, again, your personal or professional life, can you think of a situation where you've been called upon to determine who's lying about a particular situation or who's telling the truth?
Same type of thing within coaching, dealing with parents and with youth. Sometimes you do get people that kind of bend the truth, and it's just a matter of not necessarily proving that they're lying, but you kind of pick up on different patterns as you get to know the people and get to know the parents and the kids. You pick up on their patterns and you start to understand when they kind of possibly are bending the truth a little bit.
Okay. So in that situation, one of the things that you would be doing if you're a juror is, number one, resolving a conflict, right? Mm-hmm. And conflicts that may emerge in the jury room as well, right? Conflicts between other jurors. Do you recognize that?
I've never thought of that, actually.
Okay. So you may be in a jury room, and let's assume, or hypothetically, there's a particular piece of information or evidence that you or that one juror thinks is extremely important, and that another juror or jurors think is irrelevant, right? That is ultimately a conflict between the jurors, right?
Yeah.
How would you approach that situation based on your personal and professional experiences?
I think by giving each juror a chance to state what their thought process is, why they think this thing is irrelevant or irrelevant, and getting the next person to do the same thing. And then from there, we would have to kind of discuss, I guess as a group, we would have to discuss on what makes sense.
Okay.
And there's always a possibility that maybe, depending on what it is, they possibly could both be right, one could be wrong, one could be right. But I think it would come down to a group discussion to kind of determine which way to lean on that. Okay.
And in terms of, the type of person you are, obviously we're taking you at face value. We don't know what's in your heart or your head. Let's assume that it's you that has a very strong opinion that this piece of evidence is relevant or important, right? And others just think that that's nuts. Mm-hmm. that it's not relevant. Are you the type of person who agrees merely for the purpose of consensus, or do you stand your ground and defend your position?
Yeah, I have no problem standing on what I'm saying or what I believe until proven otherwise.
Okay.
That's definitely just who I am.
Okay. And in terms of your again, your role as a juror is to determine, you may have two witnesses who testify, right? And they're both looking at the exact same piece of evidence or the same event or whatever, but they interpret it or view it differently, right? So your job is to determine which of these people's testimony is credible. So who's lying, who may be lying, or who may be telling the truth about a particular situation. Other than kind of hearing out both stories, what tools can you bring to that analysis?
I think it's a matter of, so like I said, that listening aspect is important, and understanding what's the thought process behind it. I think that kind of is how you determine that, or at least for me, is just understanding the thought process behind it, and it would have to make sense logically to me individually. So if it doesn't make sense logically to me as a person, it would be hard for me to comprehend it.
Okay. Well, you said something interesting a little bit ago, too, in terms of until you would be proven wrong or proven otherwise, right? There was
Correct.
a comment in that. So can you think of a situation in your life where you have been 100% certain about something only later to determine you were wrong?
Yeah, I don't have an exact example, but it does happen. I mean, like with maybe my siblings or my friends, we might be discussing something, and I was plenty. I mean, like I said, I talk sports a lot with my friends, so we might be discussing maybe a stat or something, and I could be so adamant on this is correct, and they might pull it up, like actually look it up, pull up the stat, and I might be wrong. I have no problem admitting when I'm wrong either, so. It's just a matter of, okay, well, you pulled it up, and now that's what that is. I am 100% wrong.
Okay. And so are you the type of person who kind of draws from that experience, and maybe next time you're talking stats, you remember that? And
Oh, yeah, I definitely remember. Yeah.
Okay.
So then that's kind of put in my back of my mind and kind of cataloged in my brain.
Okay, great. So again, one of your jobs as a juror is the judge will give you the law. You'll sit through the trial. You'll hear all of the evidence. You'll hear all of the testimony. And at the end of the trial, the judge will give you rules of law. Are you able to, A, listen to the entirety of the evidence in this case in an impartial manner?
Absolutely.
So any prior opinions you may have formed about this case, you're telling us you can set those aside and judge this case on the evidence as presented in court alone.
For sure.
Great. And at the end of the case, then, the judge will give you rules of law. And I know that you're not a lawyer, so, but you may read the law and you may think it's wrong or that it should be changed. You may have an opinion about the law. Are you able to apply the facts as you hear them in court to the law, even if you disagree with the law?
Yes.
Okay, great. So I have a few just sort of follow-up questions on your questionnaire, sir. And again, I know it's been a couple of months since you've answered these questions, and I'm not trying to trick you or anything like that, okay? The first question that you're asked is some questions about what you remember hearing about the case. And you gave a pretty detailed response based on what you had seen in the news. I mean, generally, you remember that?
What was the exact question?
I guess that was sort of a confusing question.
Yeah.
Do you remember what you wrote about what you had heard about this case, generally?
I don't remember what I wrote, but I mean what I heard was pretty much the facts where I don't know what I wrote, but yeah, so it's pretty much I have no idea what I wrote.
Right. You remember hearing that Mr. Floyd had attempted to buy something with a fake bill or check, right? And somehow he ended up on the ground with Chauvin using his knee against Floyd's neck to hold him in place. Crowd surrounding, they start recording. So it's basic recitation of what you understood happened on that particular day, right?
Right.
And ultimately you understand, or you remember hearing that there were two autopsies, one that said Floyd may have died from a previous condition and another saying something else. So if you were, again, in this case, to be listening to the evidence, and say, for example, only one autopsy is presented in court, can you set aside what you may have heard about any other information and only focus on what is presented in court?
Yeah, for sure.
Okay, great. Now you were asked a couple of questions about your impression of Mr. Chauvin and Mr. Floyd. And with respect to both of those individuals, you have a neutral you indicated you have a sort of a neutral opinion. And ultimately, with respect to Mr. Chauvin, you wrote, "I do not believe the defendant set out to murder anyone. However, based on the video, I'm not sure about what the reasoning could be." Do you remember writing that?
No, but I still I stand on that still, but I don't remember necessarily writing that.
Yeah, sure. And again, I'm not. That's what you.
Yeah.
I'm not trying to trick you. Would you be able to listen to what people may come in and say about police training, about police practice, and what any potential reasons may be?
Yeah, I mean, like I mentioned earlier, a lot of times I like to understand the thought process behind something. That's kind of how I understand things is by hearing somebody's thought process and letting them actually speak their thoughts.
Okay, so let me skip ahead a little bit. In any criminal trial in this country, the defendant has no obligation to ask a single question, present any evidence, and obviously the defendant has he has the right to remain silent.
Absolutely.
Right? So if you're not able to hear directly from Mr. Chauvin would you hold that against him about what his thought process was?
No, because I believe, isn't it then a matter of whatever's presented then? So I mean, I would have to come to kind of in my own brain, kind of come to some type of conclusion on what, or I guess the court would have to come to some type of conclusion on what the process was. I mean, since he would remain silent on that. So
okay, so you're willing to adhere to that principle of law?
Yeah.
Okay, great. And with respect to Mr. Floyd, you say, I view him as just an average regular man, no other information about him?
Correct.
Okay, great. It indicates that you, there's a question about watching a video of Mr. Floyd's death and how many times you think you had seen that video. And so I just want to make sure we're on the same page as to what video you're talking about and what video we're talking about, all right? Because it may be different. There was you understand that a bystander filmed this incident. That video got uploaded to a social media platform, and then it went viral. Is that the video you think you have seen in the past?
I believe so. It was a bystander uploaded social media video.
Yep. Okay. And then have you seen any other videos, because there were other like body-worn cameras that had been released, there were some security cameras that people released. Have you seen any other video of the incident?
No, I have not.
Okay. Now, in terms of that video, the bystander video, have you watched it in its entirety, or have you just seen what was presented like on news channels as part of smaller segments as part of the story?
I've not seen it in its entirety.
Okay. But you've seen 30-second, maybe a minute clip here and there?
Yeah.
Okay. And you indicated at that time you'd seen it 2 to 3 times, right?
Mm-hmm.
Is that
maximum?
Okay. I understand.
Yeah.
Understand you weren't counting, thinking that you needed to ever be asked that question. But you also indicated that you have talked with some family and friends or coworkers, or potentially discussed it online. I want to kind of parse those into 2 categories.
Okay.
You've talked about it with your friends and family, right?
Mm-hmm. Yes, correct.
Have you posted any opinions on social media about it?
No.
Okay. But when you've talked with your friends and family, you wrote, "My opinion has been, why didn't the other officer stop Chauvin?"
Okay.
Do you remember? I mean, can you explain that a little bit more, or what opinion you had formed about that?
About which part? Which?
About well, you say, "My opinion has been, why didn't the other officers stop Chauvin?" I mean, just what do you mean by that opinion?
Meaning, why didn't the other officers do any type of intervening or something? That's all I mean.
Okay. I'm just curious in terms of your impression of Officer Chauvin,
Yeah.
right? So did you form the opinion that he was doing something wrong?
I don't know if he's doing something wrong or not, but somebody died from the situation. So I mean, I like I said, I don't think he had any intention of harming anybody, but somebody did die. So even if you have no intention of doing something and something happens, somebody could have possibly still intervened and prevented that.
Okay.
Yeah,
and
that's
that-
kind of my thought process.
That makes
So it's kind of like if say if I'm not paying attention and I'm driving my car, somebody can still tap me and say, "Hey, pay attention." So I mean, that's my thought process. Is somebody can intervene regardless of just somebody can intervene if something's going possibly wrong.
Okay, fair enough. You were asked a couple of questions about, you were asked a question about the impact to the Twin Cities community in the aftermath of Mr. Floyd's death, the protests, and your response was that you have, there was asked if you think the Twin Cities was positively or negatively impacted. And you responded, neither. The protests have the potential to have positive impact, but I have seen no impact so far. Can you explain what you meant by that?
Meaning, so when I say it has the potential to be positive, it just means that what comes from that just hasn't happened in terms of if there's possibly changes that need to be made. Just what needs to happen in general, just in order to see, because like I said, somebody did pass away from this, so something positive either has to come from it or nothing comes from it. It was something positive could be, like I said, just simple, maybe a few changes in the way things are handled. I don't know. I don't know what they could be, but I do feel like something positive could possibly come from it. I don't know what negative could come. Like, I'm not the type of person that kind of harps on the negatives. I don't even know what the negative impacts could be personally.
Okay. You were asked a question about whether you have personally ever seen the police use more force than was needed. And you checked the box yes, and you wrote, in downtown Minneapolis, I've seen police body slam, then mace an individual simply because they did not obey an order quick enough. Was that, like, it's obviously something you personally observed, right?
Correct.
Was it a friend of yours, or were you just a passerby to that situation?
Just passing by.
Okay. Did you see the entirety of the contact between the police and this individual, or do you think it's possible you may have missed something?
I definitely could have missed something. I just was walking down the street.
But you formed the opinion based on what you saw that the police used more force than was necessary in that circumstance?
Absolutely, yes.
Okay. And are you able to set that kind of aside, and you understand that situation is different than this situation, right?
Absolutely, yeah, both isolated incidents.
Okay. Now, you didn't give us much information, and you remember you have the ability to say that something is private, but you were asked, have you or someone close to you ever been arrested for a crime? And you wrote yes. And how you thought the police handled that arrest? And you said they acted professionally. Was that a personal situation or a friend?
Personal.
Okay. Was that the driving ticket that you referenced later?
Yes.
Okay.
So yeah.
And it was like a bad license or something like that?
Yes, correct.
Okay. You were asked a series of questions about there were a series of just blanket statements. And then you were asked to rank your opinion from strongly agree to strongly disagree to each of these statements. And there's just a couple I want to cover with you. And then I am nearing the end of my questions for you, sir. In terms of these statements, there is a statement that reads, discrimination is not as bad as the media makes it out to be, and you strongly disagreed with that. Can you explain your thinking in that?
I think it's well beyond what the media can even report. Just in general, just because discrimination is such a broad thing. It's a broad spectrum of things. It would be impossible for the media, I think, to cover it all, because it could be some of the smallest things can be discrimination, and sometimes there's just no way for it all to be covered.
Okay. So you think that there's more discrimination? You interpreted that question to be that there's more discrimination that has occurred than the media could just ever even cover.
Correct.
Do you think that sometimes the media exaggerates discrimination?
Well, yes. I think that's part of their job, I believe.
Okay. And do you think that there are certain circumstances where something could be perceived as discrimination even though it wasn't?
Yeah. I wouldn't say that it wasn't, but I mean, some of discrimination is perception.
Right.
So I can't say that somebody else's perception is automatically incorrect.
Right.
That's their perception. If they feel like they were possibly discriminated against, I feel like they have the right to feel that way.
Sure. But can you also see how the other person who is conducting the discriminatory act may have a different perception?
Absolutely. And I think that's where, just in general, better communication, needs to be done.
Sure.
It's just a matter of communicating the thought process and what's going through each person's mind.
Okay. You also, there's a statement that says, police in my community make me feel safe, and you somewhat agreed with that. Is there a reason that you may feel that police aren't making you feel safe?
Well, just like the incident from earlier that was just stated where I seen the kid kind of get slammed to the ground. That doesn't necessarily make me feel safe, but also, like the gym I go to, there's a few officers that go there that they're great guys. So it's like that's where that somewhat comes in. I wouldn't want to see anybody get body slammed, but also I know some great guys. So
okay. In that situation, did you try to intervene with the police, or were you just a passive observer?
Just pass by.
Okay, gotcha. There is a statement that says, "I support defunding the Minneapolis Police Department," and you somewhat disagreed with that. Can you explain that?
Yeah, I don't quite know what defunding would look like all the way. I haven't read up enough on it. So I don't know whether I would completely disagree or agree. I know benefits to the police. I guess I don't know enough on it to really. I would have to read up a lot more to actually form a strong opinion.
Sure. You were asked a couple of questions about both the Black Lives Matter movement and the Blue Lives Matter movement. You indicated that you have a very favorable impression of the Black Lives Matter movement, and you wrote, "Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they're black." Can you just explain that a little bit more?
Explain my answer?
Yes.
Could you repeat what you explain?
Sure. What you wrote is, "Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they are black."
Okay.
So I guess I'm asking is, I understand that your perception of the Black Lives Matter organization is favorable, but
can I pause you? I don't know Black Lives Matter as an organization.
Okay.
I don't know it as an organization. So maybe that's. I don't know if that's how the question said. I don't know if it said Black Lives Matter organization. I don't view it as that. So I don't. Okay. That's not how I subscribe to that.
So I think it's been in previous jurors, it's been sort of somewhat described as a movement on one hand and organization.
I don't think of it as either. I just think of it as a statement.
Okay, fair enough. And with respect to the Blue Lives Matter, you had a neutral opinion, and you wrote, "Although I do believe officers' lives matter, I feel like the concept of Blue Lives Matter only became a thing to combat Black Lives Matter, whereas it shouldn't be a competition." Stand by that proposition?
Yes, because like I said, Black Lives Matter is just a statement. It's not a thing. It's just people of black, pigment, their lives matter. It's just a statement.
Sure, and I agree.
Yeah.
You have a friend or relative who works as a corrections officer, is that right?
Correct.
And again, without identifying the organization with whom he or she works, is that local here in the Twin Cities?
Yes.
And by corrections officer, do they work actually in the jail, or do they work like as a probation officer in the community?
In juvenile detention centers.
Okay.
Yeah.
All right. If you were to, you understand that many, I don't know if they're a civilian person or a trained deputy, but if you were to sit as a juror on this case, would you call up your relative and say, hey, this is what they're saying is training, that's proper training. Is that how you guys are trained?
Nah.
Okay. So my last questions for you, sir, have to do with the last question on the survey, which the last two questions are, do you want to serve as a juror in this case? And you checked the box, yes. And you were then asked why. And you said, because of all the protests and everything that has happened after the event, this is the most historic case of my lifetime, and I would love to be a part of it. Can you just explain your thinking in terms of how did the protests and things that have happened afterwards have to do with the facts and evidence in this case?
Well, there's no correlation between the protests and the facts. The facts are the facts. There's no correlation between those two things.
Okay.
Me stating that this is possibly a historic moment is just based on the different movements that have come from this. That's just the fact of the matter.
Sure. So I mean, it's kind of what I understand you to be saying is that this is a historic event in many regards, right?
Yes.
And again, you're willing to listen to the facts and evidence in this case, apply the law, and be a fair and impartial juror.
Correct.
All right. If I may have just a couple minutes, Your Honor. Follow-up question, sir. So I understand that you coach youth sports, right?
Correct.
And I don't know anything about where or whom or anything of that nature. I guess the question that I have for you is, if you understand that one possible outcome would be a not guilty verdict.
Correct.
And can you foresee a circumstance where you would be agreeable to a not guilty verdict?
Yes.
And would you be able to go to the kids you coach and explain why you did what you did?
Yes.
Okay. Your Honor, we'll pass for cause. Thank you, Your Honor. Sir, good morning.
Good morning.
One of the interests that you indicated that you had, questioned by counsel, was in writing.
Yes.
Can you please tell us a little bit about what kind of writing you do?
Well, I enjoy, I guess, creative writing, just different writing projects in terms of scripts, poems, just any type of creative writing.
And do you publish any of these, or are you
No.
trying to publish?
Nope, this is just for my own personal, it's just a personal hobby.
So notice that you've spent some significant time in the banking industry.
Yes.
Without discussing your specific employer, can you please share with us what is it about the banking industry that draws you?
It's the consistency, the freedom that it allows me to, I guess, help others in a way. In the specific type of banking that I'm in, I can kind of see people's goals come to fruition. That kind of gives me a sense of accomplishment.
In the role, in the job description that you provided, it seems that you are probably one of the individuals who's interacting with the customer one-on-one quite a bit. Is that right?
Yes, correct.
Would you describe yourself then as a people person?
Yeah, for the most part, yeah.
Introvert, extrovert?
Probably more extrovert than introvert.
I wanted to ask you a few questions about drug use and whether you know anyone or have observed a friend or even an acquaintance struggle with illegal drug use.
Yes, I have.
And can you share with us a little bit your opinions of people who may struggle with drug use?
My opinion on them is no different than my opinion on anybody else. It's just something that they're struggling with, that they're possibly trying to get through, but they're still just like anybody else.
Would it be fair to say that you would not judge someone more favorably or less favorably if you learned that they had a struggle with illegal drug use?
Correct.
Now, of course, I asked you about your job and what drew you to that. Can you tell us a little bit more about what draws you to coaching youth sports?
Like similar to my job, I can kind of see, this time kids set a goal or just grow in general and to be positive adults. To me, that gives a sense of accomplishment for myself, to see them grow into adults, to successful adults.
Now, this probably has never happened, but one could hear of a situation where, say, a parent could be a little overly enthusiastic during a game and maybe give you some coaching advice on the spot. Does that ever happen to you?
All the time.
Right?
All the time, yeah.
And maybe a couple of parents could maybe have disagreements about how much playtime their kid's getting.
Yep.
Have you ever seen a situation where two parents, either on the same team or opposite teams, kind of start getting into a conflict or a yelling match?
Yes.
Have you ever done anything to calm or de-escalate that situation?
Absolutely. With me being kind of the coach and kind of that mediator, that middle person, I can they kind of would listen to me and I can let each person get their voice heard, let each person talk, and kind of let them figure it out that way by me being the mediator and letting each person get their voice heard, communicate, and see if they can come to a common ground or agree to disagree.
I wanted to ask you another question about an answer you gave regarding, we were talking about the issue of intent. Mm-hmm. And I believe that you expressed the opinion that you believe that no one had an intent to do any particular harm that day, the day of George Floyd's death. Is that right?
Correct.
You understand that if you're called to serve as a juror, you have to set aside all opinions. Intent is an issue that will be contested in this case. Do you think it would be difficult for you to do that, or would you be able to look at this case completely as a clean slate?
I don't think it'd be that difficult at all. I think I can definitely look at it from an unobjective point of view.
One moment, Your Honor. Thank you, Your Honor. The state passes for cause.
All right, juror number 52. You are going to serve on this jury.
Okay.
And so we're going to reconvene for the trial itself on March 29th at 9 a.m. As you've seen, there are sometimes delays. If that time changes, we will advise you accordingly. In fact, we'll probably call everybody or send an email just as a reminder in any case. But if you don't hear from us, it's March 29th at 9 a.m. The deputy's going to take some paperwork from you. But in the meantime, remember, do whatever you can to avoid reading about this case, watching on TV. Avoid it as much as you can so that everything you decide in this case is going to be based on only what you hear in the courtroom. Any questions?
No, sir.
All right, thanks. Then you can go with the deputy. We're going to break. Yeah, it's 10:30. And we're going to take our morning recess. So let's reconvene at, we'll shoot for around 1:45, no earlier than 10:45. All right, thank you. 29th is going to be juror 54. Great. Thanks for my mask in there. Could you get that? I forgot I had my Thanks. Morning, sir. Why don't you come on up? Sitting right next to me.
And you want this?
Now you can hold on to that and give it to the deputy when we're done here.
Oh, okay.
Well, good morning. You are juror number 54, correct?
Yes.
All right. Before I turn questioning over to the attorneys, a few matters. First of all, I'm going to swear you in so that all your answers are under oath.
Okay.
If you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. I am going to keep my mask on, and the attorneys have plexiglass in front of them. You have plexiglass in front of you, and we have plexiglass between us. And I'll keep my mask on. You, however, may, if you wish to be heard more clearly, or just if it's more comfortable, you can take it off at any point if you'd like.
Okay, well, if they can't hear me, just let me know and I'll take it off.
Okay, and generally I can understand you. We might have you pull just a little closer to the microphone, not right on top of it, but that's good. And unfortunately, it doesn't move very well. It's pretty much
Okay.
hardwired.
So that's good?
That I can hear you, and I'm sure they will as well.
Okay,
But like I say, if it's more comfortable at any point, feel free.
okay.
I kind of leave it to you to decide that.
Mhm.
So you filled out a questionnaire, and it looks like you gave it a lot of thought, and we appreciate that. Is there anything, or first of all, is everything true on that questionnaire?
Is there anything not true?
Yeah, is there anything that
No.
anything you wanted to add or amend?
I don't think so.
Yeah, just because sometimes you fill it out in December, and people realize, oh, I probably should have put this. In reflection, there might have been more information, or maybe even you change some of the opinions in it. Anything you can think of right off the bat? And it doesn't have to be. I'm just saying if there is
No,
something.
I don't think so. I don't remember exactly what I said about how easy or difficult it would be to be impartial.
Right. And I think we'll talk about that a little bit.
Okay.
And the lawyers, when they're talking to you, will kind of refresh your memory with specific items.
Sure.
So feel free to have them read back what your answer was. It's almost more common than not that most jurors say, I don't remember what I said in answer to that question.
Yeah.
So feel free to ask for a prompt there.
Okay.
And just a reminder that anything you say, even if it's different than what was in the questionnaire, that's perfectly fine. All we're looking for are honest, candid answers. The only failure as a juror is if you say something that's not true about yourself. Okay?
Yep.
Now, you were not supposed to read any articles, and the questionnaire told you avoid all media. But we realize that you may be exposed inadvertently to information about the case. You see a headline, maybe a friend talks to you about the case, and since we told you don't tell anybody you're a potential juror, you can't exactly stop them. Did anything like that happen to you, that you've come across to any inadvertently any information about the case or any related civil litigation or the parties or the attorneys, anything like that?
No.
Okay.
No.
Right. Now, the reason why we ask all these questions is obviously you need to decide the case just on what's in the courtroom, the evidence and the law as I give it to you. And if you can do that, great. But if just knowing yourself, if you say, I can't, I would like to, I would try to, but just knowing myself, I know that I couldn't be impartial, for example. And I bring that up because there's quite a bit in your questionnaire about that. And it's not a failure as a juror to say, if you can't be impartial, you can't. If you can be impartial, also a good answer if that's the truth. So let's talk about partiality or impartiality. Do you think in this case you could be an impartial juror?
That's the biggest struggle I have.
All right, tell me a little bit more about kind of your thought process and the struggle internally.
I didn't even see the whole video. I saw as much as I could take of the video, and I was appalled by what I saw, and that feeling continues to be with me. And then I thought, well, can I move from that? Can I find myself in a position where it's almost like I can forget that I've seen it or something?
Right.
And I've been struggling with that now for months.
Right.
And I can't make any headway on it.
Okay. Let's talk about it just a little bit. If this were, well, I guess, would you be in the same position as a juror as far as your partiality if it was not quite such a high profile case? And you had not
say
seen,
more about what you mean by that.
well, and I guess, let's say it's something you really hadn't seen much about, but maybe the nature of the charges would cause you to be that I can't be impartial. I can truly be a blank slate, even if the charges were similar, different case totally.
Okay, well, the thing that hangs me up a lot on this one is that, as I understood it, the immediate error that George Floyd made was in trying to pass a counterfeit bill. At least I think it was counter anyway. And then the action that was taken seemed to me to be inappropriate.
Okay.
More physical force than seemed to go with that kind of a charge.
Okay.
And I mean, if anything, maybe Mr. Floyd needed some medical attention before the other took place, the
Right.
charge. And to exert that kind of force for that long just seemed out of line to me.
Okay. It sounds like a fairly firmly entrenched opinion.
Well,
you
that's
have.
the problem, yeah.
Yeah, and I want to make something clear. I have never met a juror in my 14 years on the bench, roughly 14 years on the bench, who did not try to do their duty and did not try to be fair and impartial, but recognizing that trying in this case is not good enough. Can you, looking inside yourselves, can you be impartial?
I wish I could say for sure that I could,
Right.
and I cannot say that for sure. I think I would be tainted.
Well, and when you mention taint, one of the things that is one of our bedrock principles is the presumption of innocence, and presuming someone is innocent of the charge. And sometimes, based on what you've seen and heard, people cannot do that. Do you think you fall into that category? That it would be very hard. I think you mentioned that in one of your questionnaires answers.
Yeah, I'm sorry that I
Don't apologize.
No,
it is what it is.
and I'm sorry to Mr. Chauvin. I'm sorry to the court, but that's just where I am. I could not say I honestly would be an impartial juror.
All right. Well, sir, I do appreciate your honesty and you're willing to say that, if that is in fact the truth, and I have every reason to believe it is. It's clear from your questionnaire that you are a thoughtful person, and that you put a lot of introspection into this, the answers you've given not only today but in the questionnaire. So I do appreciate your time and you're taking the time to do all this. I am going to excuse you from this jury. So you're off jury service unless you get a summons in the future.
Okay.
All right.
And if I can just add one other thing, when it first came, I saw that because of my age, I could ask to be excused.
You can.
And I thought, well, I'm a reasonably healthy 75-year-old. I should be able to do this. And so I thought, well, I'll proceed with it and see what I can do.
Well, I appreciate that because a lot of people exercise that right off the bat.
Yeah.
So
Yeah.
I appreciate your willingness to do your civic duty, but recognition that there are limits.
Yeah.
So
Okay.
thank you so much. You can go with the
Well,
deputy.
thank you.
You bet. You can take that and give that to the deputy.
Okay. All right.
Thank you. Juror 55, I believe. Is that? Come on up. Morning.
Good morning.
And you are juror 55, correct?
Correct.
All right. A couple things before I turn it over to the attorneys for questioning. First thing is to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Now, I'm wearing a mask. I'll continue to do so. You have plexiglass between us and in front of you. The attorneys have plexiglass in front of them. Now, my point here is, if you would like to remove your mask to be heard more clearly, or because it would be more comfortable for you, feel free to do so. And I'm kind of leaving it to you on how you want to proceed. In any case, if you could speak near the microphone, I think actually you're about right.
Okay.
I think that generally will pick you up, and I'll adjust as much as I can to make sure that you are heard. First of all, you filled out the questionnaire. Thank you so much for taking the time to do that and to submit it to us. There's a lot of good information there for the lawyers to ask you about. First of all, is everything true on the questionnaire?
Yes.
And any changes or additions to the questionnaire that you can think of right now?
No.
All right. The questionnaire did advise you not to read any articles, avoid any media about this, but we recognized back in December when you filled this out, or January, that time has passed. You inadvertently may have been exposed to some information about this case. For example, maybe seen a headline in passing, or a friend or relatives talks to you about the case, and we told you don't tell anybody you're a juror, so you couldn't exactly stop people from doing that. Have you learned anything about this case since December and as you sit here today?
No. I've chosen to avoid it as much as possible.
Okay, great. So nothing about not only the facts of the case, but about maybe the parties, any related litigation, anything like that?
No.
Okay. Any pretrial matters, anything about the case or the procedures that have been around the case?
No.
Okay. Excellent. The whole point is, as a juror, you have to decide this case only on the evidence that you hear in the courtroom, apply the law as I give it to you. And so while everybody has heard something about the case, to varying degrees, do you think you could do that, is put aside anything you may have heard or seen about this case and decide the case just on what you hear in the courtroom and apply the law just that I give to you?
Yes, I do.
Okay. All right. You were given a list of witnesses. Anybody look familiar on that list?
No.
All right. All right. We had an estimate of trial of 4 weeks, basically. And I think you had some concerns about the length of the trial. Can you tell me about those?
Just for my work purposes, just to let my employers know how long I'm be done, and because I am working on some projects right now, just how to deal with those without causing questions upon my colleagues is where I'm at.
Okay. And you mentioned financially it might be hard for you. Have you found out, does your employer pay you for jury duty?
Yeah, that's all taken care of and
Okay.
addressed, so I don't have to worry about that anymore.
All right, so that's not a concern. It's more the substance of your work. And
Correct.
do you think you might be trying to do some work after hours to?
Yes, I've had long discussions with my employer just to be prepared, and we've already worked out the working agreement, so I'm good.
Okay. All right. And when asked whether you weren't sure you wanted to be on the jury, and you noted some, do you have concerns for your personal safety?
I do for afterwards, because I know
Okay.
then it will be a public information, and it really depends on how the trial, the end result is, and I, being as this is new to me, I just don't know what I'm to be facing.
Right.
And just want to be prepared.
Okay, and you understand that you are anonymous at this point.
Correct.
Will remain so through the trial. At some point in the future, and not even immediately after the verdict, that's up to me to determine on when it's appropriate to do so. I would, your name would become public, a part of the public record. That doesn't mean you have to talk to anybody, but it could become part of the public record.
Correct.
Knowing all that, do you think you could decide this case and not, without worrying, well, I better come to this verdict or this verdict, because otherwise I might be in trouble?
The verdict isn't the real answer. It's the fact of how people perceive it, because everybody's going to perceive it differently based on the outcome. It helps me to know that it's not going to be public right away, because hopefully some time will have passed before it's public and everybody will move on.
Right. Okay, great. I'm sure the lawyers will probably follow up on that as well.
Correct.
Do you have any questions before I turn you over to the attorneys?
No.
All right, Mr. Nelson, as to juror number 55, you may inquire.
Good morning, ma'am.
Good morning.
What I'd like to do here this morning is ask you some kind of general, broader questions about yourself, about your experiences, and then focus into some of the questions that you answered on the questionnaire.
Okay.
All right? Assume you and I met under a different circumstance at a social event or a party, and we're engaged in a conversation. What are a couple of things I'm going to walk away knowing about you after that conversation?
Depends on the topic of conversation, of course. I'm a single parent. I work in the healthcare field. I sell Pampered Chef as a side hobby. Those are the main things I talk about with people.
Okay. And you have 2 children, right?
Correct.
And one's older and one's in her teens or his teens?
Correct.
Okay. When you, at some point, you learned that you were a prospective juror in this particular case, right? What was your initial reaction to learning that you were being called in this particular case?
Being as it's my first time, I thought, wow, first time on such a big case, kind of a thrill and caution at the same time, because with everything going on in the world now, you just never know how things are perceived, and my first reaction is I'm going to do the best I can if chosen, because that would be how things work out. I'm going to give my best opinion and make the case very fair.
Okay, great. Can you think of a situation in your personal or professional life where you've been required to sort of step in and resolve a conflict between 2 people?
In my current role, I do that quite often.
Okay.
I work a lot with the patients. If there's patient issues, I'm usually one of the first people out there to deal with the patient and help resolve the issues that they are dealing with our particular clinic.
Okay. And so when you're involved in that kind of a process, how do you approach the resolution of conflict? What are some tools you bring to that?
Well, first is listening. You have to listen to everything. Sometimes they just need to vent, and then you pretty much have to figure out what is their main issue and try to resolve it and see if I can resolve it within my means. If not, I'll do my best to come up with a win-win for both of us.
Okay. Now you understand that, I guess in the context of being a juror, that's ultimately part of what your role is conflict resolution, right?
Correct.
There's obviously a conflict between the parties in this case, as well as there may be conflict that arises in the jury room.
Correct.
Okay. If you were, let me ask you this, if you were in the jury room and a particular piece of information comes out in trial, right? And one group of people they think they're adamant that this is the most important piece of evidence. Another group of people is saying, well, that may not be as relevant. How do you approach that situation?
I would have to be neutral, and I have to give each group the opportunity to show why they feel that way, and yet, after hearing both parties, come up with my own resolution and say, well, what about this? Because I'm going to have to share my opinion at some point in time. But being able to hear both parties, a lot of times that's all they want to know. And then it's a matter of you trying to bring out things that, well, I'm questioning this. Why are you saying this? And why are you saying this? And maybe even possibly have some insight from both parties on different ways of looking at things.
So listening to both sides of the story is an important factor, and looking at what other information may support one side or the other is an important factor. Okay. How about in your personal or professional life, a situation where you have been called upon to determine who's telling the truth about a certain circumstance?
I would say more in my professional I deal with this more, but it's a matter of gathering the facts. And I'm hoping I will be presented the facts to know how to make that decision.
Okay. Can you think of a situation in your life where you were 100% certain of something, you'd formed an opinion, only to later learn that you were wrong?
Nothing comes to mind. Sorry.
Recognize it's a possibility?
Oh yes.
Okay.
Always.
Would you be the type of person who learns from and tries to apply that to similar situations in the future, or would you be the person kind of brushes it off and says, mistakes happen?
I'd use it as a learning opportunity for sure.
Going back to the the situation, let's put yourself back in that jury deliberation room, and rather than being two sort of competing factions over a piece of evidence, you're now the person who's adamant about this information is incredibly important, right? But a contingency of the other jurors are saying it's not that important. Are you the type of person who can, kind of stand by her principles if you form that opinion, or are you going to just agree with the others simply to build consensus?
I'm the type of person that is going to expect or want them to hear my side of the opinion and have them try to prove me wrong so that I can show them maybe a different side of something. Okay. I'm not going to just go with the flow type of thing, especially if I feel really strong about something. I'm definitely going to want to be heard.
Okay. But you'd still be willing to re-examine your views on this?
Oh, absolutely.
Okay, great. And the last kind of general question is your job as a juror is to hear all of the evidence in court, right? Set aside anything you may have learned before that's not presented in court. And at the conclusion of the case, the judge will present you with the law, right? Are you able to read the law and apply it as the judge gives it to you, even if you think the law is wrong or should be changed?
I'm not in a position to change the law. I'm in the position to uphold the law and bring it forward to whatever the case is.
Okay. So I am going to focus your attention on a couple of your questions, and again, no one's trying to trick you or anything of that nature. If you want, I will in all likelihood just simply read you your responses.
Okay.
And we will then explore it a little further. Okay? So the first question kind of asks you to write down what you remember seeing or hearing about this case in the news or the media. And in your answer to that, you wrote, "I heard about this on the news, but could never fully watch the whole thing, as this disturbed me that the officer didn't change or remove his knee placement." Do you remember?
Yep.
Okay. Now, I want to, by the thing, we're talking about a video. Is that correct?
Correct.
And I want to make sure we're kind of on the same page. There was a video that was taken by a bystander. That video got uploaded to Facebook. It went viral, and it became a news story.
Correct.
Is that the video that you're referencing?
Yes.
And there's a question later in the questionnaire that asks you how many times you've watched that video, and you wrote, I believe, once, but I didn't even finish the whole thing.
Correct.
So in terms of that video, how did you come to be familiar with that video? Was it through social media? Was it through the news media? How did you learn about that video?
The news media.
Okay. And so the videos that were shown on news stories, were they more smaller clips or as a part of a larger story, or were you watching some news media and there was a link to watch the entire video?
It was a short clip.
Okay. Did you ever go and I want to see what's more about this and look up the actual full video to watch that?
No, I have not.
Okay. when you were asked about that video, you said that you couldn't watch it in full because it was too disturbing for me. Do you remember that?
Correct.
Is it fair to say that you formed an opinion about what was happening in that video simply based on watching that video, or what parts of it you watched?
I would say it's the fact that someone was harming someone else from what I'm seeing, and I just couldn't watch that. Whether just based on the human-to-human information that was being presented during that video, I just couldn't watch it anymore.
Okay. Now, let me ask you, there was a question later in the questionnaire about being able to see graphic images, graphic types of, whether it be video or photographs, and you had some trepidation about that. Would you agree with that?
You said trepidation?
Yeah, like just nervous, like you were concerned about that.
Yes, I was concerned about it.
Okay. So it's entirely possible that the entirety of that video could be admitted as evidence in this case. Would you be able to watch the entire video?
I would, based on my role in this, I would have to, because that's part of the whole evidence.
Now, also, would you agree that that video is really only a part of the story?
Correct. I definitely agree with that.
Okay. And you have never gone and have you ever seen any other videos of this incident, whether they be the police officers' body-worn cameras or any of the like surveillance videos that were released?
No, I have not.
Okay. Would you be able to, again, wait until all of the evidence is presented and decide this case based on the entire story and both sides of that story fairly and impartially?
That is my role here.
Now, you were asked a couple of questions about your general impression of both Mr. Chauvin and Mr. Floyd. And with respect to Mr. Chauvin, you checked somewhat negative, that you had formed a somewhat negative impression of Mr. Chauvin. And you wrote, I think they could have handled it differently. I got the impression he didn't care about George Floyd, or GF is what you technically wrote. It's okay to have an opinion, all right? We all have our own opinions about virtually everything. Can you set that opinion aside? And you formed a somewhat unfavorable opinion of my client, agreed?
Correct.
Can you set your opinion aside and judge this case based on the facts?
I believe I stated in my questionnaire that I don't know that based on the little clip that I've seen, that I've even gotten all the facts to form an opinion. Okay. And I won't be able to form an opinion on him until I have all the facts. And that's what someone should do.
Okay. And feeling the same way about Mr. Floyd as well? Yes.
I think he has more to bring to the table, as Chauvin does.
Okay. Now, in terms of some of the general rules of law, you were asked some questions. You're able to apply the presumption of innocence to Mr. Chauvin at this point?
Yes.
You understand that under our system of law, under our Constitution, Mr. Chauvin has nothing to prove here.
No.
Okay. He doesn't have to ask, we don't have to ask a single question. We don't have to introduce a single piece of evidence. We don't have to participate in this process. Do you have any problem with that?
No, because I feel right now he's innocent until we can prove otherwise.
Okay, fair enough. And I think you've made that quite clear in the course of your questionnaire, so I appreciate that. You were asked a question about your impression of whether the community has been negatively or positively affected by any of the events that have taken place in the Twin Cities area since Mr. Floyd's death. And you wrote, I think all our communities took a beating from these. Unfortunately, a negative one. Everyone was scared it was going to come to their neighborhood. So, I mean, can you explain what you kind of mean by that?
There's just a lot of riots that were being taken place around the Twin Cities area, and I know in other communities as well. And based on where I lived, there was one taking place not too far from where I live. And that's pretty far from Minneapolis, and so it kind of spread to other areas outside of where the incident happened.
Okay. Do you think there's a difference between a riot and a protest?
Oh, yes.
Okay. Can you see the difference between the protests that occurred after Mr. Floyd's death and the riots that took place?
Yes.
Do you think that they're one and the same?
No.
You were asked about past your observations or your own personal past police contacts, and you were asked the question, have you ever personally seen the police use more force than was needed? You wrote yes, and you wrote, I wouldn't say more force, but I have seen more officers respond to a situation than I thought should or needed to. A teenager, unarmed, nothing in hands but a water bottle, get addressed at a park regarding his actions. Over 4 officers showed up. I felt like he was being harassed. That's what you wrote.
Yep.
Can you just tell me a little bit more about that situation?
I was out in the parks walking with my girlfriend, and we were sitting on a bench, and a young man came walking down the path, tennis shoes. All he had in the water is a water bottle, and a lady came up and was yelling at him. And then pretty soon a cop showed up, and we're in where the playground is for younger kids, and pretty soon there was 4 cops there. And I'm thinking, he is unarmed, he's got a water bottle, I don't understand, and it was in a public place. You're causing, to me, undue, they could have taken him someplace where it was less public to make such whatever happened. He ended up walking away.
Okay. So you just thought that they, more officers showed up, they kind of harassed the kid, or young man, I should say, and it was an unnecessary police response. Would that be a fair summary?
I would agree, yes.
Is there anything about that situation that would affect your view of this case? Like, would you say, so many officers showed up on this case?
I wouldn't know that. I only know what that little clip showed me. I don't even know how many officers were there, how many showed up. I'm just witnessing based on what my incident was at the park, and this was after the incident, and I think cops are probably on edge right now. They're looked at in the microscope, and that's too bad, because that's not their role. They're here to protect us, and it's just too bad that I witnessed that particular incident on a young boy with just a water bottle in his hand. I mean, if he had anything that I felt in his hand that was a threat, then I totally agree with the number of officers that showed up.
Okay, fair enough. There were a list of several kind of broad statements, and you were asked to sort of rank your opinion of these statements from strongly agree to strongly disagree. Okay. So my question is about just a couple of those I want to follow up. You were asked the question, police in my community make me feel safe, and you checked the box, I somewhat agree with that. Can you explain your thinking there?
That was just based off that incident that I'd seen in the park.
Okay. You were asked the question, police in this country treat whites and blacks equally, and you somewhat disagreed with that.
I think it's really based on the officer and their opinions and how they address people. I know without personal experience, but I've just heard that some officers aren't the best and they don't treat everybody equally, and I think they should. Doesn't matter who they are, they should treat everybody the same. Whether they pull them over for this, they pull them over for that. We shouldn't have, based on your racial and how you look, determine how you get treated when you get pulled over.
Okay, fair enough. You were asked your opinions on both Black Lives Matter and Blue Lives Matter, and I believe you sort of have the same response, at least generally. You write, I believe all lives matter, doesn't matter the color of their skin or nationality they are, all lives matter, underlined.
I truly believe that.
But yet your opinion of Black Lives Matters was somewhat unfavorable. Why would that be?
I'm not sure why I answered that, because I still strongly believe that all lives matter. It doesn't matter who they are, what they are, they all matter. We're all important.
Now, I know your employment takes you, or you work in a clinic setting.
Correct.
And I'm assuming with doctors and nurses, and you have relationships with doctors and nurses in a professional context.
Correct.
If you were a juror on this case, would you call up one of your doctor or nurse friends and say, this is what these doctors are saying?
Absolutely not.
Okay. You did initially, I just want to make sure I heard correctly, you initially had some concerns about your employment and finances and things like that. That's all been taken care of, I'm assuming?
Correct. Yes.
Okay. The last question you were asked as a part of this questionnaire is, do you want to serve as a juror on this case? And you checked the box, not sure. You are nervous. You wrote, I'm nervous. I've never been a juror before, and to be on such a high-profile case. Would people know I am a juror on this case during or after? Question. Would I question during and after? I don't want to walk around or be in my home and not feel safe. That's what you wrote.
Yep.
So let me ask you a couple of follow-up questions on that. How did you feel when you came down to the government center and saw sort of the fortifications, for lack of a better word, around the area?
A little concerned, but there wasn't as many there as I anticipated to be, so that made me feel better. But knowing that there's so much security here, I feel better, and the fact that the jurors are not going to be, names aren't going to be released before, during, or hopefully a while after. Being as I'm new to this, I didn't know what to expect, and so I just was voicing my opinion because I just didn't know what I didn't know.
Sure.
So
now that you have seen how we're dealing with this situation, you know your anonymity is, we're attempting to protect your anonymity, you feel more comfortable and willing to serve?
yes.
May I have a moment?
All right, Mr. Slisher.
Thank you. Good morning.
Good morning.
Noticed on your questionnaire you indicated one of your hobbies is motorcycle riding.
That's correct.
Right. Can you tell me about that a little bit?
I have a 2019 Softail Heritage Classic, and I like to ride whenever I can.
Okay. Do you just within the state, or do you travel?
Being it's just recently new, so I just strictly stay within the Twin Cities kind of metropolitan outskirts area. Not a lot of riding I do.
Haven't ventured out to Sturgis or anything?
No. Not recently. Many years ago I did, but.
All right. One more, I'm sorry. And what got you interested in motorcycle riding?
What interests me?
Yes.
My late husband was really into it, so I got my license just to make sure that if anything happened to him, I could still ride. And I ride with him, kind of now in the spirit. So.
Well, thank you for telling us about that. You were asked some questions about the difference between a protest and a riot, and you said you understood there is a difference. What I would like to ask you is if you can tell us in your own words, as best you can, what is the difference in your mind between a protest and a riot?
A protest is somebody walking around with signs who made note of a particular topic or interest, and a riot is one when they actually do harm to buildings to cause attention.
And you said that there were some riots or property damage that happened fairly close to your residence, is that right?
Correct.
What went through your mind when this was all unfolding?
I'm concerned that it was going to come into my neighborhood and wondered what do I do during that circumstance. And I guess I just was concerned that what do I do? Do I call the police? Will that, put salt in the wound? Do I just let them do their thing? I mean, I think with anybody it was the question, how do they handle it if it comes close to them?
And what did you ultimately do?
Nothing. I stayed in my home and did nothing and hoped that it didn't come.
Did that work out?
It did.
You didn't suffer any property damage or anything like that?
No, sir, I did not.
And did any of your friends, neighbors, relatives suffer any property damage?
No.
You indicated that you watched the video one time, but you had not watched it since because you found it disturbing. Is that right?
To be clear, I've never watched the full thing.
Okay.
So I don't even know what happened after I heard him say something. I totally shut it off. So I've never seen the whole video in its full entirety.
And you shut it off specifically because you found it disturbing?
Correct.
But you've indicated that, if that's something that you had to view again, you would be able to do that.
I would have to.
Taking you back to your description of the incident you saw at the park in which you believe that officers used too much force, you recall that?
Correct, yes.
Do you recall the race of the individual against whom you believe they used too much force?
The individual, the boy, was white. Not that that made any difference to me, but it was just the fact that there were so many officers.
And you felt that under the circumstances, they just simply over-responded?
Correct.
And I just want to go over again the conversation that you had with defense counsel about your views of Black Lives Matter. And you indicated that you had a somewhat unfavorable view of Black Lives Matter, and said you weren't really sure why you wrote that, the unfavorable view. Can you just, upon reflection?
I still really don't know where I was when I wrote that, but maybe I was thinking that sometimes, or maybe they were taking it too far. I don't know exactly why I answered that way. I'd have to probably try to remember where my mind was at that time, or did I witness something or see something, or I just can't fully answer as to why I would write that, because something must have happened or triggered me or that, because usually I don't, like I said, all lives matter to me. It doesn't matter who they are, what they are. They all matter because we're all important in this world.
And the question I had was, maybe do you associate that group with property damage or rioting?
No.
And do you believe that if someone was to make the statement that Black Lives Matter or some other lives matter, that they're saying other lives don't matter?
It can be perceived like that,
Okay.
and I think they are just making it, maybe they felt, and I don't know because I'm not Black, to know maybe they felt that they were never heard, and that's why they are coming up with Black Lives Matter, because maybe they felt that they never were seen, they never were heard, and whereas I don't believe that to be true, but I'm not them, and I might see things in a different view.
And so when you say someone could perceive it like that it could mean that they're saying not all lives matter, do you perceive it that way? When you hear that someone say Black Lives Matter, do you perceive that they're saying that not all lives matter?
It can be perceived. Whether I perceive it like that, that's a great question. I would probably just tell them that all lives matter again.
Mm-hmm.
So maybe I do perceive that they think only Black lives matter.
And then so the next question or series of questions had to do with Blue Lives Matter. And so when you hear someone say Blue Lives Matter, do you perceive that in the same way, that maybe they're saying not all lives matter, only blue lives matter?
I took that to perceive everybody else. Blue lives will, maybe I'm misinformed, I don't know what Blue Lives Matter mean, but I took that to mean that that's everybody else.
So I should follow up. I mean, what is your understanding of what that means if somebody were to say Blue Lives Matter? What, in your
And
own
have them
words?
clarify, what do they mean by blue? What
Okay.
does blue mean?
Okay. What did you think it meant when you answered the survey?
That meant everybody else.
Everybody else. Did you associate, or have you ever associated that Blue Lives Matter with police officers?
Oh, so that's what that means. Is blue means officers. Huh? Say that question again now, please.
Sure. And I think you answered it. But at the time you were filling out the survey, did you have an understanding that Blue Lives Matter actually refers to police officers? Blue lives.
I can honestly say no, I didn't perceive it like that because I didn't know what blue meant.
Okay. On the survey, you indicated that you believe that sometimes local police departments will cover up instances of excessive force rather than to correct it. You said you somewhat agreed with that proposition. Do you recall that?
That's probably based on my witness in the park, because when we were walking down the path and the officer told us to stay back, and I'm like, well, I'm kind of concerned for this one kid. There's like 5 officers, and he said, stay back. And I'm like, okay. So, I mean, that was my only, I've never had any incidents or witnessed anything other than that one incident at all with any police officers at all.
It sounds like that made an impact on you, though. You remember how long ago that was?
It was last summer, August, September. It was a really nice day. We were out walking. We were just out for a long time. We were out for a long walk, and that was just, something happened right in front of me, which I've never been witness to, and that's probably why it's stuck with me, because it's my only incidents that I've seen.
When the officer, so you indicated that you saw something that concerned you, but the officer told you to stay back and repeated it?
Correct.
How did it make you feel when the officer said that to you?
Kind of like I didn't matter, that I was concerned with the particular boy that was being harassed is how I looked at it. That I should mind your own business type of thing.
And you said that the officer said this twice. Did you attempt to argue with him or ask a question?
No, I'm not in any position to argue with an officer. I just stayed back.
Okay. Do you know why he said it twice, or?
To probably make his point across.
Okay.
I don't know.
It wasn't in response to you asking a question or attempting to insert yourself?
I just was, like I said, I was walking up to him and he said, "Stay back." And I said, "Well, I just concerned for that kid." And he said, "Stay back."
Okay.
And so I did.
Okay. Sometimes when I ask a question, people tell me I'm arguing, so I just needed to clarify. Not you.
No.
All right. Do you have any concerns that, with the precautions we have here, the plexiglass and mask wearing and whatnot? Do you feel that we've adequately taken steps to reduce the risk of COVID-19?
Yes, you have.
Okay. Do you think it's enough or maybe even too far?
One cannot be too cautious.
One moment, Your Honor. Can you tell me a little bit more about your work as an executive assistant, what it is you specifically do, without naming your employer, giving any identifying information?
Yeah, I work as in the executive assistant in a clinic in Minneapolis, and I assist the VP and director of our actual building. So I work with a lot of her meetings and his meetings, just going over things and issues that happen across our building. That's pretty much sums up my role.
Okay. And so you're working with someone in the sort of an administrative position. You're not working with a physician?
I work with physicians only if it has to do with meetings and such, not on a day-to-day basis do I get in touch with them.
Okay.
I know who they are, but I don't work with them on a direct basis at all.
So, for example, working specifically with cardiologists or pulmonologists?
No, not on a day, only if it has to do with a meeting request, and then I usually reach out to their assistants.
Well, is it fair to say that you do have and place trust in police officers?
I have placed a trust, and that's their role, and that's I have nothing but to believe that until they show me something different.
And so with that, understanding that in this case, there will be law enforcement officers who will be called to testify. There will be civilian bystanders who will be called to testify. And you would be asked to judge their credibility to determine whether or not one should be believed or another one should be believed. And based on your trust in police officers, I just need to ask you if you would be able to look at the testimony of a police officer in the same manner that you would look at the testimony of some other witness who wasn't a police officer, perhaps a bystander.
Absolutely. Doesn't matter. Their uniform doesn't change who they are.
You don't think that you might tend to believe a police officer more simply because they are a police officer?
Not necessarily.
Right. Thank you very much. Your Honor will pass for cause.
Juror number 55, you will be on this jury.
Oh, okay.
So, you can go about your business until March 29th at 9 a.m., which is when we anticipate starting the trial itself.
Okay.
And so, we will be in contact probably to remind you or to tell you if things have been delayed. I think you've already realized sometimes there are delays.
Yes.
And we apologize for that, but it's just the way things happen. So we do appreciate your time here. And the deputy will take some stuff from you on the way out, but unless you hear from us otherwise, March 29th at 9 a.m., you'll be escorted to that same courtroom to wait.
Okay, so I come in like to
Same process, same process as today, same places where to park, all that kind of stuff.
Okay.
All the same, and you'll go to the same courtroom to start off with.
Okay.
All right?
Sounds good.
Okay, thank you. This is going to be juror 56. And we may not be able to get through juror 56 completely, but we'll give it a try. Dana, if we go to 12:30,
Yeah.
Okay. Morning, sir.
Morning.
You have a seat right there.
Okay, just put this right here.
Yep, wherever you can find space.
Okay.
All right. Well, thank you for being here this morning.
you.
And I'm going to first thing swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. And I'm going to ask that you speak into the microphone if
Okay.
you can.
Yep.
I'm going to keep my mask on.
Okay.
We have plexiglass between us, plexiglass in front of you, plexiglass in front of the attorneys.
Yep.
So that's sufficient for us to say, if you'd like to take your mask off to be
Okay.
more comfortable.
Yeah, that's fine.
That's fine that you can do that.
Mhm.
All right. Before I turn it over to the attorneys, I want to ask you a couple questions.
Sure.
First of all, everything true on your questionnaire?
Yes.
All right. Any changes or additions you can think of offhand?
There is one,
Okay.
and that was in regards of knowing a police officer.
Okay.
I
Tell us
put
about
in my
that.
questionnaire that I didn't. Well, at the time, I thought he was no longer in the force. But
Okay.
it come to my attention that he is now still on the force.
Okay. And do you know which police department this person is on?
I don't know what Minneapolis, but I don't know what precinct.
Okay. All right. And I think you've just illustrated one thing we find is that people fill out a questionnaire in December and then on reflection they realize there are things,
Correct.
oh, I probably should have put this in or I found out new information.
Yeah, at the time I didn't know.
Okay.
It came to my attention, a family member let me know that he did. He was let go and then he got back on the force.
Okay. Okay. Is there anything else you can think of that might be you want to change or add to? Because it's all right, actually, if you even change something.
Right.
Opinions evolve, facts come to light that you think show that something was inaccurate. The most important thing is that you just give us as accurate and as honest an answer.
I mean, there are some things that come to my attention, you know, that I've heard
Right.
on the television. It was hard for me to get away with watching the television because of where I'm located at work at the break room. They always have a TV in there.
And I think you've kind of anticipated my next question is, you're told in the questionnaire to avoid all media coverage of this.
And to my best I could.
Right. It's not uncommon from the jurors we've talked to find that inadvertently people have been exposed to more information about the case. They see something on TV, a quick headline, or in the newspapers.
Right.
So tell us, first of all, what you know about the case.
Well, I know what I've seen on the video.
All right. Have you watched the video a few times?
I've watched it twice in
Okay.
its length.
The whole thing?
The whole thing, yes.
Have you sought out that video, or did it just when it came up on the news?
When it came up on the news.
All right. What facts do you recall from watching the video?
Well, I know the facts that the officer had his knee on his neck
Okay.
for over 8 minutes.
Okay.
And I know there was other officers
Okay.
there at the moment. Yep.
All right. And you formed some opinions based on what you've seen and heard.
Correct.
I'm going to focus now on since you filled out the questionnaire and today.
Mm-hmm.
What have you heard or seen? And again, we acknowledge that sure you did your best to avoid it, but some things are unavoidable.
Right.
What information have you found out about this case or
What-
anything related to this
Okay.
case?
What I did hear is that there was a potential plea,
Okay.
but the Attorney General denied that plea.
Okay.
And I also know that the third degree was put back on the table.
Okay. And so these are like headlines you've seen and things
Yes.
like that. Okay. Do you think you could still presume somebody innocent when you've got maybe more information than you wanted about
Sure.
it? Okay.
Yes.
You can still presume the defendant innocent, or do you think now?
Well,
it's-
from what I've seen, it would be tough.
Okay. All right. Let me talk to the lawyers just for a second. All right. Juror 56, I'm going to release you from this panel. It's not your fault that you inadvertently got exposed to things that would make it tough to be
Right.
sitting as a juror on this case. Because, like I say, you're in your work situation that
In the break room, it's hard to turn off the TV when everybody else is watching it.
and you can't. And we told you don't tell anybody you're a potential juror, so you can't say turn that off. I don't
No,
know.
I wasn't about to do that.
All right, and so because of that, obviously not your fault. But I'm going to release you from service on this panel. And
Okay.
so, in fact, you're released from jury service. So unless you get a summons in the future, you'd be fine.
Okay.
All right.
Thank you very much.
Thank you, sir.
Yep. Have a good day. And this just
You actually give to the deputy, and he'll take care of it. All right, it's 5 to 12. We've run out of jurors, so we're getting better at calibrating how many jurors we have. Although I still feel like a cat chasing a laser pointer, but nevertheless, I think we have no choice but to recess until 1:30. The jurors are summoned for 1. We've got 3, so I think 1:30 would be just fine that we start. All right? See you at 1:30.